Welcome to the deep dive. How do we navigate this really intricate world where the state interacts with its citizens? Makes decisions that impact our daily lives and, well, wields considerable power. Today, we're taking a deep dive into the foundational concepts of administrative law and its profound constitutional underpinnings. It's a really core area. Now, this deep dive, focusing on these core principles of administrative law and its constitutional underpinnings, is brought to you by Sinorbit Academy, Sri Lanka. And we also want to extend a huge thank you to the University of London for making these invaluable documents available for educational purposes. Seriously helpful stuff. And to all of you preparing for your exams right now, good luck. We know it's a stressful time. Our mission today is pretty clear. We're going to extract the most important nuggets of knowledge from our sources, try and connect the dots between ideas that might seem separate at first glance, and hopefully provide you with a clear, structured understanding of this crucial area of public law.
We're going to clarify definitions, explore the essential functions, and even get into some of the big ongoing debates that shape how administrative power is, well, controlled and held accountable. So let's get started. Okay, let's unpack this then and maybe start by connecting some dots, because for anyone studying public law, you'll find pretty quickly that administrative law isn't some, new isolated island. It's actually deeply connected to the constitutional system you've already been exploring. In fact, understanding these connections is absolutely crucial for really grasping administrative law itself, wouldn't you say?
Oh, absolutely. That's exactly right. Administrative law truly builds directly on those foundational public law concepts you've already covered. If you think back to your public law studies, you introduced to the constitutional system in the UK, right?
Yep.
The major institutional players, Parliament, the executive, the judiciary, and the various sources of power that shape the whole legal landscape. This includes primary legislation acts of Parliament, the highest form of law we have. Then there's secondary or delegated legislation, where Parliament gives power to ministers or public bodies to make more detailed rules. Think regulations, orders, that sort of thing. And even the exercise of prerogative powers, those ancient powers of the crown, now largely exercised by government ministers without direct parliamentary, like declaring war or making treaties. These are the very powers that administrative law then seeks to regulate, you see, to ensure their exercise lawfully and fairly. So understanding these links, these fundamental building blocks from public law, is truly the first crucial step. You can't really understand the controls without first understanding the power they're designed to constrain. Let's maybe revisit some of these core concepts and explore them a little deeper. First up, the separation of powers. Now, this is a foundational idea, creating this conceptual division of governmental functions into three distinct branches. You've got the legislature, which is Parliament, making the laws; the executive, which is the government of the day, responsible for implementing and administering those laws; and the judiciary, our courts, responsible for interpreting laws and settling disputes. Now, in the UK context, it's vital to remember that the separation here, well, it's not as rigid as, say, in the United States. There isn't that strict formal division. Right, because ministers sit in Parliament.
Exactly. In the UK, the executive, primarily through ministers, is drawn from and accountable to Parliament, the legislature. So there's a significant overlap. But the core principle still holds. Each branch has certain tasks allocated to it. However, as Endicott points out in his work, I think it's table number 1, there's inevitably some overlapping competence between them. For example, the executive makes vast amounts of secondary legislation, so it's acting in a sort of quasi-legislative capacity. And tribunals, which are technically part of the executive branch, perform quasi-judicial functions, deciding disputes. So the separation of powers provides the very framework within which administrative law operates. It aims to keep each branch in check, especially the executive, which is the primary focus of administrative action. It's really about preventing the concentration of power in any one place. Okay, next, let's delve into the rule of law. Many of you will have come across the Diceian concept of the rule of law. The idea that no one is above the law, everyone's equal before it, and government power is exercised under law, not arbitrarily. That's the classic starting point, isn't it? The constitutional orthodoxy.
It is. It underpins so much of our understanding. However, Endicott offers a broader, perhaps more general account, which is incredibly useful for our purposes in administrative law. Why? Because it speaks directly to the nature of administrative governance itself. He argues that the rule of law requires, firstly, the life of the community is governed by clear, open, stable, prospective general standards. So, law should be accessible, understandable, apply to the future, not retrospectively change the rules.
Okay, so clarity, openness, stability looking forward.
Precisely. Secondly, that government officials adhere to those standards. This is crucial. It means officials, from the top minister down to the person processing your application, must act strictly within that legal framework.
No making it up as they go along.
Exactly. And thirdly, critically, that there are independent tribunals, i.e. courts, that regulate the conduct of the other institutions. This highlights the judicial role in policing the boundaries of executive power, making sure they stick to the rules. The enduring power of Endicott's definition and what makes it so vital for understanding admin law lies in these core tenets. Let's repeat them. For clarity, this is really important for exams. 1. Clear, open, stable, prospective general standards govern the community. 2. Government officials adhere to those standards. 3. Independent courts regulate the conduct of other institutions. This ensures governmental power stays within legal boundaries, preventing arbitrariness, ensuring fairness and predictability for citizens.
Clear standards, adherence, independent courts.
Okay.
It's not just a theoretical ideal either. It's a constant tension in modern governance, especially, with digital services evolving so fast. Maintaining clear, open, stable standards can be a real challenge there. And finally, let's touch on accountability. This is a core focus of public law, and it's basically about ensuring that those who exercise public power are answerable for their actions. Now, accountability is a multifaceted concept. It's really, really vital not to get lost thinking that only legal methods courts are appropriate.
Right, because we see accountability in Parliament, too.
Exactly. While legal accountability, primarily to courts and tribunals through things like judicial review, is a key component, there are many other equally important forms. You've got political accountability, predominantly to Parliament. Ministers answer questions, face debates, appear before select committees to justify their department's actions and policies. That's huge. Then there are other forms, often less formal maybe, but no less significant. Think about audit accountability for how public money is spent. Bodies like the National Audit Office scrutinize spending, looking for value for money, preventing waste.
So, checking the finances.
Yes. And consider accountability through inspections and ratings. Think Ofsted for schools, the CQC for hospitals, HMICFRS for police forces. They provide public-facing assessments of performance and quality.
Those reports everyone looks out for.
Exactly. And critically, there's accountability through publicity and the media. This links directly to freedom of expression, the public's right to know. Investigative journalism, freedom of information requests, public debate, they all play a massive role in holding power to account by shining a light on what government does. All these methods are important ways accountability is delivered in modern societies. So the key point here is that while legal accountability, especially judicial review, is what administrative law often focuses on, it's just one crucial piece of a much larger, more diverse, interconnected puzzle of control mechanisms. They often complement each other, sometimes overlap.
That is a really intricate web of accountability. It definitely underscores the complexity of modern governance, doesn't it? So what you've just heard is how these core public law concepts, separation of powers, rule of law, that multifaceted accountability, they aren't just textbook theories. They provide the absolutely essential theoretical bedrock for understanding how administrative law actually works. It's like the skeleton, isn't it? The structure, making sure power is exercised responsibly. And that leads us nicely to a finer point of distinction within this field itself. We often hear administrative law and administrative justice used, maybe even interchangeably sometimes. But are they really the same thing? Or is there a crucial nuance we need to grasp for our deep dive today? Let's try and get precise about these terms and understand the real difference.
Indeed, it's really crucial to distinguish them because while they are related, their scope and focus do differ. Let's start with administrative law. Generally, this is defined as the body of law that regulates relationships between the citizen and the state, or maybe more broadly, between the citizen and various public authorities. Fundamentally, it's about public power. Now, this field has two primary aspects that are important to grasp. First, it can be facilitative.
Facilitative, how so?
Well, it helps ensure that public administration is carried out effectively and efficiently. It provides the legal framework, the procedures that allow government bodies to function smoothly and, crucially, lawfully. Think of it as the how-to guide for lawful administration.
Okay, making things work properly.
Right. Second, and this is often more predominant in the UK context, it is regulatory. This aspect focuses on controlling the behavior of public authorities, making sure they stay within their proper legal boundaries and don't abuse the powers Parliament has granted them. It's the thou shalt not aspect, preventing illegality, irrationality, procedural impropriety. Now, a key contrast here is how the UK model differs from other places. In England and Wales, a lot of our administrative law is judge-made. It's evolved through court decisions, through precedents, and a great deal of it is regulatory rather than primarily facilitative. This is quite different from, say, many European states or the USA, where public administration is often governed by detailed administrative procedure codes.
Like a big rule book for government actions.
Exactly. Those codes not only regulate how authorities act, but also actively facilitate how administration can be carried out lawfully through very specific, often highly detailed provisions. So in the UK, the emphasis leans heavily towards the courts acting as a check on power, correcting errors and abuses, rather than proactively guiding efficiency, if that makes sense.
It does. Courts as regulators, mainly.
Now let's turn to administrative justice. This is a bit more complex, definitely a broader concept. It's crucially important from your perspective as a student because it emphasizes that controlling public authorities goes beyond just administrative law and the formal courts. It highlights that actually a huge amount of the work in resolving disputes between the citizen and the state happens through methods other than formal court proceedings.
Like what, for example?
Well, think about the vast number of complaints handled internally by public bodies themselves, or by ombudsmen, the parliamentary ombudsman, the local government ombudsman, or by specialized tribunals like those dealing with Social Security or immigration. Mullen provides a very useful definition here. He explains that the term administrative justice can be used in two distinct ways, prescriptively or descriptively.
Okay, prescriptive versus descriptive. Let's break that down.
Right. Used prescriptively, administrative justice refers to the principles we use to evaluate the justice inherent in administrative decision-making. It's about setting the ideal standards for how administrative justice should work. This includes both substantive elements, which focus on correct outcomes, making sure people get what they're entitled to, like benefits or licenses, or avoid unfair burdens. And it includes procedural elements, focusing on fairness and treatment, ensuring people are treated properly, like the right to be heard, to get reasons for a decision to be treated without bias. That's the prescriptive use, the ideal.
So what should happen for it to be just? Both outcome and process.
Precisely. Then, used descriptively, administrative justice denotes a field of inquiry. It's about grouping together and analyzing the various social processes related to decisions and actions by government bodies. Mullen uses the term here to refer essentially to all decisions made and actions taken by government bodies, so the justice in question is that owed by the state to the citizen, or sometimes from the citizen to the state. It's a pragmatic look at how the system actually works in practice, encompassing all the avenues a citizen might pursue to challenge or understand a government decision. So, just to make sure we're clear on Mullen's definition, let's recap. The prescriptive use is about the principles for evaluating justice, covering both substantive outcomes and procedural fairness. And the descriptive use is about the field of inquiry itself, grouping together all the social processes of government decision-making, judicial and non-judicial, for analysis. This highlights that administrative justice is broader than administrative law in some ways, as it includes a wider set of dispute resolution mechanisms beyond just courts and tribunals. But it can also be narrower in focus, predominantly dealing with regulating state activity and resolving grievances, rather than the facilitative side of administrative law.
Okay, so what this really boils down to for you, the listener, is a huge practical point. Most administrative grievances are actually dealt with outside of the formal judicial review system. Think about it. Internal complaints, ombudsmen, those specialized tribunals, they're all part of this wider administrative justice landscape, and they resolve countless issues without ever needing a high court judge. So if accountability is so multifaceted, does that mean judicial review isn't always the first or maybe even the best solution for every single grievance? What does that mean for how we sort of categorize these different avenues?
Exactly right. The control of public authorities involves a much wider range of mechanisms than just the courts. Understanding this broader context of administrative justice is absolutely key to appreciating the full picture of how the state is held to account and how grievances get resolved often more quickly, more cheaply through non-judicial routes. This understanding is critical for students because it moves you beyond a purely court-centric view of how administrative power is controlled, and that brings us quite naturally to a crucial question. What are the core functions that administrative law and administrative justice are actually designed to serve? If we connect this to the bigger picture, it's about much more than just stopping bad decisions or fixing individual complaints. It's about shaping how government operates and making sure it serves the public good.
That's a perfect segue. Leyland and Anthony provide an excellent framework here, one that really encapsulates the broad objectives of administrative law and justice. They suggest a number of core functions which really highlight how multifaceted this area is.
Indeed, they do. The first function they identify is control. Administrative law aims to control the arbitrary or unlawful use of governmental power. This links directly back to Endicott's focus on arbitrariness and the crucial role of law through principles like legality in checking the misuse of power. It's fundamentally about ensuring public authorities act strictly within the bounds of their legal authority, the powers granted to them by Parliament. They shouldn't exceed those powers.
That's the classic ultra vires idea, isn't it? Acting beyond your powers.
Precisely. Closely related is the function of command. The courts, through administrative law, can command public authorities to use their power in a lawful manner. Now, this isn't just about preventing abuses, it's also about preventing authorities from arbitrarily withholding the use of their powers when they have a duty to act.
So forcing them to act when they should.
Yes. For instance, if a public body has a legal duty to provide a service or make a decision, administrative law ensures they fulfill that duty, not just that they don't exceed their powers when they do act. It's about ensuring proper exercise, not just preventing improper exercise. For example, if a local council has a statutory duty to consider certain factors before making a planning decision, admin law commands them to actually do so. Then there are the positive principles to facilitate good administrative practice. This is a really critical point that goes beyond just stopping unlawful acts or compelling duties. It's an argument that the administrative justice system should also be about channeling public authorities towards improving their decision-making processes and overall governance, making things better, not just stopping bad things.
So promoting good practice, not just punishing bad practice.
Exactly. Endicott makes a similar point when he discusses concepts like good and reasonable government, suggesting admin law should actively foster better governance. This might involve encouraging transparency, requiring reasons for decisions, promoting consultation, maybe even fostering a better culture of public service within government bodies. It's about encouraging best practices, setting standards for efficiency and quality, and a recurring theme, as we mentioned earlier, is accountability and transparency. Leyland and Anthony, along with Endicott, are pretty much in broad agreement here. A core aim of administrative law is ensuring the exercise of public authority is accountable and transparent. Endicott even calls this the principle of open government.
Letting the light in.
Pretty much. It means citizens should be able to understand how and why decisions affecting them are made, who is responsible, and have clear ways to challenge them. This function ties directly into that broader concept of administrative justice, encompassing everything from freedom of information requests to public consultations. It aims to prevent secrecy and build trust. Finally, we have grievance redress. Leyland and Anthony emphasize that administrative law ought to provide effective mechanisms for people to sort out their grievances. While maybe not a primary focus of Endicott's first chapter, it's certainly implicit that citizens who are in dispute with the state about their rights should have a way to seek a remedy. This is clearly a vital part of the role of both administrative law and administrative justice, ensuring individuals can challenge decisions that adversely affect them, whether it's an unfair benefit decision, an unjust planning refusal, or an incorrect tax assessment.
And that redress could come through courts, tribunals, ombudsmen.
Exactly, or even internal complaints systems. Now, while these objectives are broadly agreed upon, even if described slightly differently, it's important to remember they're delivered by a variety of institutions, not just the courts via judicial review. And this brings us to a crucial concept. Endicott introduces the principle of relativity. He talks about this on page 13.
The principle of relativity. What does that mean in this context?
Well, Endicott argues that administrative law and the requirements it imposes must be sensitive to the specific context. They can't be one size fits all. For example, he states, the law should not impose the same forms of control on a power to conduct relations with foreign countries that it imposes on a power to detain people. Think about that for a second. The level of scrutiny, the procedural requirements, they should differ vastly depending on the nature and impact of the power being exercised.
Makes sense. You wouldn't scrutinize foreign policy secrets the same way you'd scrutinize someone being locked up.
Precisely. A decision about national security or foreign policy involving complex diplomacy, state secrets, naturally gets less intense judicial scrutiny than a decision directly affecting an individual's liberty or property rights. And this principle of relativity has a direct application for you students in understanding how effective and resource-efficient grievance redress is delivered. Minor disputes, maybe those with relatively little impact on an individual, might be best dealt with through more informal mechanisms or specialized tribunals. They're often quicker, less adversarial, more accessible, designed for high-volume, low-cost resolution. However, major disputes about the sheer legality of an action, or where there's a severe impact on individual rights and fundamental freedoms, those are likely best dealt with in the formal courts through judicial review, which offers a more robust, authoritative legal challenge. So the principle helps guide where a grievance should appropriately be addressed, aiming for both justice and efficiency across the whole administrative system.
It's fascinating how these objectives, while broadly agreed upon, aren't delivered solely by courts. It really is a whole ecosystem of control, constantly trying to balance competing demands, adapted to the context. Okay, here's where it gets really interesting, I think. We're diving into two very famous ways of thinking about administrative law, the red light and green light theories. These come from Harlow and Rawlings, and they offer profoundly different perspectives on how the state should be controlled. Understanding them is fundamental to grasping the underlying philosophy. It's like looking at the same landscape through two completely different colored lenses.
Absolutely. These theories aren't just, dry academic exercises. They represent distinct philosophies of governance, the role of the state in society, and they influence how judges, politicians, even citizens perceive administrative power. Let's try and break down the characteristics of each, understanding that they often stand in pretty direct opposition. First, the red light theory. Now, this theory emerged from a tradition that, views the state with a fair bit of suspicion, particularly the expanding powers of the executive back in the 20th century. Its proponents believe individual liberty is paramount, and the state, while necessary, is an inherent threat to that liberty.
So control is the main goal.
Exactly. Therefore, it places a strong emphasis on judicial control of administrative action, primarily through judicial review by the courts. Think of it literally as a red stoplight flashing a warning for potential state overreach. Its ideal is a limited, laissez-faire government, one with only minimal intervention in citizens' lives. This theory is, to some extent, linked with A.V. Dicey's traditional view of the Constitution, which emphasized parliamentary sovereignty, but also the crucial role of common law courts in upholding individual liberties against arbitrary power. As Harlow and Rawlings put it, the red light view of English administrative law as an instrument for the control of power and protection of individual liberty, the emphasis being on courts rather than government. So, for you, the student, the key takeaway is to think of red light theory as focusing on controlling the state to protect the individual, with the courts as the primary enforcers, and starting from a fundamental suspicion of state power.
So a red light judge might be very interventionist.
Potentially, yes. In a hypothetical case, a red light judge might scrutinize an administrative decision very closely, looking for any procedural misstep or slight overreach that could infringe on an individual's rights, even if the government's policy goal seems reasonable. Their priority is protecting the individual, not necessarily state efficiency. So let's hammer that home. Red light focuses on judicial control, suspicion of the state, and limiting government intrusion. Now, in stark contrast, we have the green light theory. This theory holds a, shall we say, less suspicious view of the state and its administration. Instead, its focus is much more on the facilitation of administrative action to achieve collective social and economic goals.
So more about enabling the government to act.
In a sense, yes. This perspective really grew during periods of significant expansion of state activity, especially after World War II. Think the rise of the welfare state, the need for government intervention to deliver public services like healthcare, education, social housing. From a green light perspective, the role of courts is generally minimized. Courts are often viewed as a potential obstruction to effective and efficient administration if they become too interventionist. However, and this is crucial, green light theorists do not accept arbitrary government. They absolutely believe in control.
But not primarily through courts.
Right. They simply believe control should come from other mechanisms, primarily political accountability to Parliament or internal administrative processes rather than judicial ones. As Harlow and Rawlings state, green light theory prefers democratic or political forms of accountability.
So for students, think of the green light theory as a go-ahead light for the state to achieve its goals, with the emphasis on internal or political controls rather than judicial ones keeping it in check.
So a green light judge might be more deferential. Generally, yes. In a hypothetical scenario, a green light judge might be more inclined to defer to a public authority's expertise or policy aims. They'd focus on whether the decision was broadly within its remit and reasonable, rather than dissecting every procedural nuance or potential individual impact. The priority is often the broader public interest and effective delivery of policy. Let's repeat that key idea. Green light focuses on facilitation of state action, preferring democratic or political accountability over judicial oversight.
So the core difference seems pretty clear.
Red light emphasizes courts and suspicion. Green light emphasizes other controls and facilitation. But you mentioned it's not always a rigid binary. It feels like the UK system often operates somewhere in between, maybe leaning one way or another depending on the issue.
Precisely. You've hit on a crucial point there. Ultimately, Harlow and Rawlings themselves take a quite pragmatic stance. They don't demand strict adherence to one grand theory over the other. They recognize that both perspectives have their uses and can be valuable depending on the context and the specific administrative function being examined. For example, in areas concerning, say, national security or foreign policy, you might see a more green-light judicial approach, greater deference to the executive, given the sensitive nature of decisions, the expertise involved. Conversely, in areas directly impacting individual liberties, immigration, welfare benefits, a more red-light approach, emphasizing judicial scrutiny and procedural fairness might well prevail. It's not necessarily an either situation, but perhaps more of a spectrum, or even a toolkit of approaches the law uses. The real world of administrative law often represents a messy compromise between these two philosophical poles. And this naturally raises an important question that sort of bridges our discussion of these theories with individual rights. What exactly is the role of administrative law in protecting the individual? It's clearly a central function, and one that's gained particular prominence since the Human Rights Act 1998 came into force. Though it's really important to understand that the courts were active in protecting individuals long before that landmark legislation.
That's a critical historical point. It's easy to think individual protection only became a big deal with the Human Rights Act. But you're saying the courts were already engaged in this much earlier. Could you expand on that historical commitment?
Absolutely. Prior to the Human Rights Act 1998, the courts definitely did focus on individual protection, particularly through developing principles of procedural fairness and what we call natural justice. This wasn't some sudden invention with the HRA, it was an evolution of the common law itself. A fantastic illustrative case, and one definitely worth remembering for exams that highlights this, is RV Local Government Board Ex Parte Arledge. It's from way back in 1915 ACU 120. This case, despite its age, remains a crucial touchstone. It demonstrates the court's unwavering commitment to procedural fairness and individual rights even a century ago, long before our modern human rights framework existed.
Okay. Arledge, 1915. What were the key facts there?
Well, in RV Local Government Board Ex Parte Arledge, the facts were pretty straightforward but had a big impact on Mr. Arledge. The House of Lords found it unlawful for the local government board to issue a closing order on his house, which he held under a long lease, on the grounds it was unfit for human habitation. Why? Because the board had failed to provide him with basic procedural safeguards before making such a significant determination about his property.
What specific safeguards were missing?
Specifically, they hadn't given Mr. Arledge an oral hearing, which he actually requested. They hadn't divulged the identity of the inspector who made the critical report leading to the decision. And crucially, they hadn't even provided him with a copy of that inspector's report. So he had no real opportunity to know the full case against him or properly respond to it.
So no hearing, hidden inspector, hidden report. Doesn't sound very fair.
Not at all. These were significant procedural failures that violated fundamental principles of natural justice. As a result, the board's decision was quashed, declared invalid. This case clearly shows that courts were very sensitive to procedural fairness and protecting individual rights, specifically the right to a fair hearing, the right to know the case against you, long before the Human Rights Act came along. So let's just embed this key example for memory. RV Local Government Board Ex Parte Arledge 1915 AC 120. Remember, the board closed Arledge's house without an oral hearing, without naming the inspector, and without showing him the report. Decision quashed due to lack of procedural fairness. It's a powerful testament to the common law's inherent commitment to justice. Now, moving forward to the impact of the Human Rights Act 1998. While the common law provided a foundation, the HRA definitely brought a new dimension and intensified the judicial focus on rights. Since the HRA came into force, incorporating the European Convention on Human Rights, ECHR, directly into UK law, there's been a renewed, and you could say increased, judicial emphasis on protecting individual rights. Section 6 of the Human Rights Act is key here. It makes it unlawful for a public authority to take any action that infringes upon convention rights, unless primary legislation, an act of parliament, specifically requires them to do so.
So public bodies must act compatibly with human rights.
Exactly, unless Parliament has explicitly told them otherwise in primary law. This has had a profound impact across many areas of administrative law, fundamentally reshaping how courts approach administrative action.
In what specific areas has the impact been greatest?
Well, for instance, in procedural justice, Article 6 of the ECHR, the right to a fair trial has necessitated quite a number of significant changes to previous administrative practices. It often requires public authorities to ensure even fairer hearings and more transparent processes, sometimes going beyond what the common law alone mandated. In the control of discretion, how public bodies use their powers, judicial review has seen a substantial change due to the widespread application of proportionality review in human rights cases.
Proportionality review, what does that involve exactly?
It means the courts will assess whether the means used by a public authority to achieve a legitimate aim are no more than is necessary to achieve that aim. It involves balancing the impact on the individual's rights against the public interest being pursued. This is generally a much more intensive, more rights-focused form of review than the traditional common law reasonableness test, like the Wensbury Standard. It requires a more granular assessment of the decision itself and its justification.
So a deeper look at the balance draw.
Exactly. Furthermore, in areas like liability and adjudication of public authorities, changes to the rule against bias have been brought about by Article 6 ECHR. It requires even greater impartiality from decision makers, extending not just to actual bias, but also the appearance of bias. The HRA has essentially provided a statutory baseline for rights protection, empowering courts to scrutinize administrative action through a much sharper, rights-focused lens.
It's clearly vital, then, as you continue your studies in administrative law and judicial review, to constantly keep in mind the HRA 1998's deep and pervasive impact. It really has reshaped how courts approach administrative action, shifting the balance towards stronger individual rights protection and introducing powerful new tools for judicial scrutiny. Okay, now we come to arguably the most complex, yet I find utterly fascinating debate in administrative law. How do the courts actually justify their power when they conduct judicial review? What are the constitutional underpinnings of this really powerful mechanism that allows judges who are unelected to scrutinize the actions of the elected executive? This is where constitutional theory really bites, isn't it? A debate that's been simmering for decades.
You're absolutely right. Understanding the constitutional theory behind judicial review is paramount because, as we've discussed, judicial review is the primary legal mechanism for shaping and controlling administrative action in the UK. And a good theory of judicial review isn't just about explaining what happens now. It should also justify why it happens and, crucially, fit coherently within our unique, uncodified constitutional framework, a framework that highly values both parliamentary sovereignty and the rule of law. Sometimes those values seem to pull in different directions.
So what does a good theory actually need to achieve? Why do academics spend so much time debating this?
Well, ideally, a robust theory needs two key characteristics. Firstly, it must have strong descriptive force.
Meaning it has to match reality.
Yes, essentially. Its premises must actually fit the current practice of judicial review in England and Wales. If a theory doesn't accurately describe what courts actually do when they review executive decisions, the grounds they use, the remedies they grant, then it lacks credibility as an explanation. Secondly, we would hope it has good explanatory force. This means it should explain why judicial review is the way it is today. It should offer insights into its historical development, how it evolved over time, and, importantly, provide some guidance for its future development. It needs to make sense of the existing landscape and offer a coherent path forward. Within this context, there are two main competing theories that have really dominated the debate. Each has its strong proponents and equally its strong critics. These are the ultravirus theory and the common law theory. They offer fundamentally different justifications for judicial review, and understanding their core ideas and their potential consequences is absolutely crucial for any student of public law. Let's start with the ultravirus theory. The core idea here is incredibly simple at first glance. Judicial review is entirely authorized by Parliament.
So the courts are just doing Parliament's bidding.
In essence, yes. The theory goes like this. When Parliament grants powers to a public authority through legislation, it implicitly intends those powers to be exercised lawfully, reasonably, and within the stated limits. It doesn't intend them to be abused. Therefore, when a court conducts judicial review and quashes an executive decision for being illegal or irrational or procedurally improper, it's not asserting its own power over the executive or challenging Parliament's authority. Instead, it's merely ensuring that the executive has acted within the powers Parliament granted it, or put another way, that the executive has not acted ultravirus literally beyond its powers. The courts are acting as Parliament's agents, upholding parliamentary intent. So the key premise here, let's repeat it. Parliament's will is the ultimate source of authority for judicial review. That's the heart of the ultravirus theory. Now, the consequence of accepting this theory is pretty significant. If judicial review is authorized by Parliament, then Parliament, being sovereign, could theoretically remove or exclude judicial review whenever it sees fit, using clear statutory language.
Like with an ouster clause.
Exactly, like trying to insert an ouster clause saying, "This decision shall not be questioned in any court." This aligns perfectly with the traditional idea of parliamentary sovereignty. Parliament is supreme. It can make or unmake any law. However, critics argue this leaves individual rights potentially vulnerable. If Parliament can just switch off judicial review, what protects citizens from unlawful government action? There are variations within this theory, too. The traditional ultra-vires theory tried to argue that every single ground of judicial review, illegality, irrationality, procedural impropriety, could be directly traced back to a literal or implied intention of Parliament in the specific statute.
That sounds difficult to prove sometimes.
It is, especially with things like irrationality, which led to the modified ultra-vires theory. This acknowledges that many judicial review principles, like proportionality or the requirement to give reasons, are largely judge-made common law principles, not explicitly written in statutes. But it suggests Parliament's general intent when granting powers is that these powers should be exercised according to the prevailing common law standards of good administration. So the courts are still, in a broader sense, giving effect to Parliament's overall constitutional intent. Okay, so that's ultra-vires. Now, on the other side of the ring, we have the common law theory. The core idea here is fundamentally different. Judicial review is justified not by Parliament's will, but by the inherent jurisdiction of the High Court and its fundamental common law powers.
So power coming from the courts themselves.
Essentially, yes, rooted in history and the Constitution. This theory posits that the courts have a fundamental, inherent role in upholding the rule of law and protecting fundamental rights, independent of parliamentary authorization. It sees judicial review as part of the court's broader constitutional function of ensuring good governance and protecting the individual against the state. On this view, the courts aren't just enforcing what Parliament wanted, they're upholding deeper constitutional values, fairness, legality, rationality that perhaps even predate and underpin Parliament's own authority. So the key premise here, to repeat, inherent judicial power, rooted in the common law, is the ultimate basis for judicial review. The consequence of accepting this theory is equally profound, maybe even more so. Taken to its logical conclusion, if the common law is the true basis, then the courts might not feel confined by the will of Parliament, especially if Parliament tries to legislate in a way that undermines fundamental rights or the rule of law.
Could they strike down acts of Parliament?
Well, in its strongest form, this theory could potentially lead to courts claiming the power to strike down primary legislation if it were deemed to violate fundamental constitutional principles. That would be a radical departure from parliamentary sovereignty as traditionally understood, a very strong assertion of judicial power. Like the ultra-vires theory, the common law theory also has variations. The traditional strong common law theory asserts this inherent judicial power quite robustly, potentially even against primary legislation. Then there's the weak common law theory, which tries to reconcile some of its more radical implications with the reality of parliamentary sovereignty. It suggests that while judicial review originates from common law, it generally operates within the framework established by Parliament. It effectively assumes Parliament wouldn't intend to breach fundamental rights or the rule of law without using absolutely crystal clear language. Both theories, as you can probably imagine, have accepted weaknesses that proponents of the alternative are quick to point out. This leads to a very vibrant, sometimes quite heated, ongoing academic debate.
So we have these two big theories, ultra-vires, rooted in Parliament's will, common law, rooted in inherent judicial power. Both have evolved into modified or weakened versions to try and address criticisms, trying to find that tricky balance between parliamentary sovereignty and judicial power. But the big question that kind of hangs over all this academic discussion is, well,
do the theories actually matter in practice? Does it make a difference on the ground which theory a judge subscribes to? This is where the work of scholars like T.R.S. Allen comes in. In a 2002 article in the Cambridge Law Journal, he was quite critical of this long-standing, sometimes seemingly intractable debate between the proponents of these two opposing theories.
what was Allen's main criticism?
Allen argues that the theories, especially in their more nuanced forms, actually have more in common than differences, particularly when you contrast the weak common law theory with the modified ultra-vires theory. He suggests that the practical outcomes in many cases might actually converge, even if the underlying theoretical justifications differ. For example, a court applying a modified ultra-vires approach might still strike down an irrational decision because it assumes Parliament implicitly intends rational decision-making. Similarly, a weak common law approach would likely still defer to clear parliamentary intent expressed in a statute, even if its ultimate justification for judicial review lies in inherent judicial power.
So the end result might be the same.
Often, yes. As such, Allen argues that perhaps we should depart from this sort of meta-theoretical discussion, this endless debate about justification, and move towards a more focused debate on what we might expect judicial review to do in the UK. He posits that instead of getting lost in the abstract constitutional justification, we should concentrate on the practical functions and policy aims of judicial review in a modern state. What should it achieve for citizens and for good governance?
So focusing on the purpose rather than the origin.
Exactly. So, for students, Allen's view presents an interesting challenge. Does it make the theoretical debate irrelevant? Probably not entirely, but perhaps it refines it, pushing us to think more about the practical functions and desired outcomes of judicial review rather than getting completely bogged down in abstract philosophical justifications. It asks us to consider the ends of judicial review, what it's for, rather than just arguing endlessly about its theoretical means or origins. It's a pragmatic approach.
That's a truly thought-provoking point. Which theory do you, the listener, think offers the strongest account of judicial review? And do you agree with Allen's call to perhaps move on, or at least shift the focus from this long-standing debate? It's a question that continues to challenge legal scholars and practitioners alike, and understanding both sides is certainly crucial for developing your own legal reasoning. So after all that, what does this all mean for you as you navigate the complexities of administrative law, especially as you gear up for exams?
What's really fascinating here, I think, is how these seemingly abstract theories and distinctions, ultravirus versus common law, red light versus green light, admin law versus admin justice, how they profoundly shape the practical protections and functions of our legal system. They genuinely impact real people and the exercise of state power every single day. They aren't just academic concepts locked away in textbooks. They're the very DNA of how our government is held accountable and how individuals like you and me can challenge decisions that affect us.
Absolutely. So to try and bring it all together and reinforce the core learning points from our deep dive today, let's summarize. First, remember that administrative law and administrative justice are broader concepts than simply judicial review. Judicial review is crucial, yes, but it's part of a much larger landscape of control mechanisms, political accountability, tribunals, ombudsmen, internal complaints. Understanding this wider ecosystem is essential. Second, the objectives of our administrative law system, controlling power, ensuring accountability, facilitating good administration, providing grievance redress, while sometimes contested in their precise phrasing, are generally agreed upon the commentators as vital functions for a just and effective state. And finally, there's no clear consensus on the theoretical basis of judicial review. The ultra-virus theory, based on Parliament's will, and the common law theory, based on inherent judicial power, remain the two main competing camps. Each has strengths, weaknesses, and modified versions, and as Allen suggests, they might be closer in practice than they first appear. This ongoing debate really highlights the dynamic nature of our Constitution. As you continue to explore these deep insights, maybe consider this final thought. In an increasingly complex world, with ever-expanding state activity, how can we best balance sufficient governance with robust protection of individual rights? And what role should the courts truly play in striking that balance for the future? Something to mull over. We strongly encourage you to delve deeper using the essential and further readings provided in your course materials. They really flesh out these concepts. We sincerely hope this deep dive has helped you connect the dots and feel more confident in your understanding of administrative law and its constitutional context. Remember, this has been brought to you by Sinorbit Academy, Sri Lanka, utilizing those excellent educational resources generously made available by the University of London. Good luck with your studies, and especially good luck with your upcoming exams.